Please, Lordship, I need a little accommodation, Lordship. I have item number 11, Lordship. Can be taken as a first item. I have some medical emergency at home now, so I have to as a first item, Lordship.
You
11.
inform the other side?
Yeah, he is here, Lordship. He's here, Lordship. He's here. Here, Lordship.
At the request of the learned counsel for the Eviction matter to be listed after the vacations.
May I please, Lordship? So with the consent of other side, I mention item 13 of today's progress. Because we received the affidavit in opposition, but replies get ready, but my client is sick, Lordship.
Huh?
My client is sick now, and we cannot file the reply. So can it be fixed after within 10 days? So
Reply business, no, nothing.
yes.
Reply will take when the matter is
So
required.
can it fix after 10 days, Lordship? Can you fix after 10 days, Lordship?
You have for the
I am the petitioner, Lordship.
interim order?
No, Lordship.
Okay. At the request of the learned counsel for the petitioner, matters can be adjourned to be listed after the vacations. Payment received.
Yes, please.
Mr. S.I. Akan, the learned counsel appearing on behalf of the petitioner, submits that the order dated 2/6/2023 passed in with petition number 6055/2021 have been complied with. He therefore submits that he would not like to press the instant. He therefore have been complied with. Also, taking into account above, the instant contempt proceeding stands dropped.
So, please.
For non-compliance of the order, my lord, started from page 13 and operative part, my lord, page 19. Last
Where is the order?
page 19, last paragraph, my lord.
Now what happened?
There, after my lord, page 20, the petitioner communicated the order, my lord, on 2nd of February 2023 itself, my lord. But the circle officer did not take action accordingly, my lord, filed appeal before the DC, my lord, page 22. Thereafter, my lord, the deputy commissioner forwarded a letter, my lord, page 28. Page 28.
Now thereafter, what has happened?
Thereafter, my
You
lord,
applied.
yes, again, my
After the
lord,
order, you applied under this Right to Public Service Act or something.
yes, my lord.
Now
Yes,
thereafter, there was some order passed.
yes,
And pursuant to that, you have filed an appeal.
no, my lord. Thereafter, my lord, page 29.
Now there is an page 20 is an application filed under section 4.
Page 20, my lord,
Then an appeal filed by whom?
by the
27.
petitioner, my lord, by the petitioner.
Then
Then, my lord, page 28. The letter issued by the deputy commissioner, office of the deputy commissioner. Page 15, dated 15/5/2020. Then, my lord, when my lord circle officer received this order, my lord, again asked the petitioner to submit online application, my lord.
Mr.
Accordingly-
Hussain, your case is a case of filing a writ petition, not a contempt.
Yes,
You were asked to avail the remedies of the alternative remedy.
Yes,
You avail them.
yes,
And thereafter, if nothing is happening
yes,
or nothing was done,
yes.
it is a case of coming under a writ. Now, against that, after applying as per the efficacious remedy,
Yes.
that having not come out. So how can you maintain a contempt?
My lord, recently order was passed by the circle officer, my lord, page 30. But the circle officer has not completed the process, my lord. This
Not
is-
process, it is, therefore it's a fresh cause of action.
My lord.
Once you
Recently,
have applied
yes,
by applying the efficacious remedy,
yes,
so the remedy having been applied, now therefore the question will be, if it is not done, it is a filing of a writ. How can you file a contempt?
because my lord, the order, there is a specific direction, my lord, to make partition, my lord, and demarcate the subject, my lord, page 90.
No, you see, it is subject to you applying.
Yes,
You applied. Now, if it is not done, it has to be in that manner. You filed an appeal against that, everything has been done. File a writ.
yes, thereafter, my lord, we have filed application, page 20, my lord,
Writ.
my lord. An application under section 4 of the RTPS Act. my lord.
Writ.
Yes, an application under section 4 of the RTPS Act 2012 as amended up to date for partition and demarcation of the so and so, so and so. Order dated 23/1/2020.
Leho. Heard Mr. M. Hussain, the learned counsel, appearing on behalf of the petitioner. The petitioner has approached this court by filing the instant application under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution, alleging willful disobedience and deliberate violation of the order dated 23/1/2023, passed in WPC number 6158/2022. Taking into account the above, this court finds it relevant to take note of paragraph number 6 and 7 of the order dated 23/1/2023, passed in WBC number 6158/2022. The said paragraphs are extracted herein below. From a perusal of the said page 19 of from a perusal of the said paragraphs, it reveals that the petitioner, the petition so filed was not entertained in view of the availability of the alternative efficacious and adequate remedy under the provisions of the Assam, what is that act? Assam Right to Public Service Act 2012. Full stop. It is further seen that pursuant thereto, the petitioner availed the remedy by filing applications to before the circle officer, assistant circle officer Bilasipara. Full stop. Thereupon, the petitioner also filed an appeal under section 8(1) of the Act of 2012. Full stop. It is further seen that the respondent authorities pursuant thereto have, it has been alleged in the instant petition that the respondent authorities, more particularly the circle officer, have not passed any order in respect to the applications so filed under section 4.
Order has been passed, my lord, page 30. But the process has not completed, my lord, page 30.
That an order, it has been submitted that an order has been passed
127/8/2024, my lord.
on 27/8/2024 pursuant to the such application being filed. Full stop. However, the process have not been completed, and as such, the instant contempt application has been filed. In the opinion of this court, the same cannot be constitute a contempt within the meaning of section 11 and 12 of the Contempt of Courts Act, more so in view of the fact that the order which has been passed, dated 27/8/2024 is gives rise to a fresh cause of action. And as such, if the petitioner is aggrieved by the same, the petitioner ought to have approached the appropriate authority or this court by filing a writ petition.
Because
Accordingly, this
My
court
lord-
finds no merit in the instant contempt petition for which the same stands dismissed. It is, however,
lord.
observed that the petitioner would always be at liberty to approach the appropriate forum or this court if the petitioner is aggrieved by the order dated 27/8/2024.
Because my lord, the order dated 27/8/24, not against us, my lord. Because this was passed, my lord, saying, my lord, this is a partial partition, so dark number and patta number will be changed. But that process has not completed, my lord.
Understood, but there is no direction to complete it on a particular date. Therefore, it is that you have availed the alternative remedy.
Yes.
Alternative remedy happens. Thereafter, you file an appeal under Section 8.
Yes.
Thereafter, there is some order being passed.
Yes.
These are all fresh causes of action which have nothing to do with the earlier one.
Thereafter, my lord, after passing order
First
by
of the learned counsel appearing on behalf of the petitioner further insists on issuance of notice for which this court is not inclined. First of, in view of that, this court imposes the cost of rupees 10,000 upon the counsel to be deposited, personal cost upon 10,000 upon the learned counsel appearing on behalf of the petitioner, which shall be deposited before the registry of this court, and the same be defrayed to the Legal Services Authority.
Sorry, my lord.
Pay that 10,000.
Sorry, my lord.
Then don't come up with all this thing. I am giving you the liberty, file a writ
Okay,
petition. Done this. The loss token copy diyo.
All right.
What is this?
Lordship may not be inclined to take up the instant matter.
Huh?
Lordship may not be inclined to take up the instant matter.
Why?
The petitioner in this case is an unwarding lockup state.
Then what happened?
She was on earlier occasion appeared on behalf of the instant petitioner. This writ petition is filed challenging the action of the Guwahati Municipal Corporation, where they illegally removed a shop of the petitioner that is in place in the land of the petitioner, and there was a shop running inside the said premises. And no notice was served to the petitioner. Case 54, Annexure 8 is the reply given by the Guwahati Municipal Corporation when an inquiry was made why that said kiosk was removed without any notice being served.
Whose shop was this?
The kiosk was of the petitioner number 1, and that is placed by the Mutwali of the petitioner number 1. And in this, with respect that kiosk, an tenancy agreement was entered into with petitioner number 2, Your Honor. And he was running a fast food in the name of Walktail, Your Honor. And
What was he doing?
he was running a fast food business, Your Honor, restaurant business, and he has valid Your Honor, permission of the Annexure 5, page 50. That is the trade license, Your Honor. So with the said trade license, he was running his business. On the night of 12th of July, Your Honor, the GMC officials came along with a crane and a dumper. They lifted the entire kiosk, which was placed in the land of the unwarding lockup state. It was neither in place in the government land, nor it was blocking any public places, causing any public nuisance, Your Honor. And without serving any so-called notice, the said kiosk was removed from therein and in place the dumper and taken away. Even after taking away the said kiosk, Your Honor, they have not informed the petitioner.
Have they issued notice?
No, Your Honor.
What is this?
Lordship, in respect of the same incident, Lordship may kindly see at page 51, one FIR has been filed for illegal trespassing. 51, yes.
Page 51 is the, if I may clear it out.
A file has been filed by
One Binod Pan, he was the, Your Honor, watchman on that day, Your Honor.
In
When
respect
that-
of the same incident, Lordship, same place.
If I may only clear it, the entire incident, Your Honor. In this FIR, the accused
So it has been done by some GMC official.
yes, sir. Firstly,
No,
this
you say this person has said that it is being impersonating as GMC official.
yes, sir. Then police after FIR, this FIR was filed, then police informed us that no, this was the GMC person, not the person accused in this FIR. So accordingly, on the subsequent page, Your Honor, page 2, a letter was written to the Garnet Mayor, Mrigan Sorenia,
So we're redressing the grievances.
I
Your
have
Honor.
the honor to inform you that movable shop in question was removed by the enforcement branch.
Yes, sir.
This is done.
Page 54, Lordship.
Yes.
Lordship, the ground has been
54.
given there.
Yeah,
During the
as
field
per the
inspection-
verbal instruction of the additional secretary
Yes,
to
sir,
the
verbal
government of
instruction.
India, what is this Department of?
Housing and urban affairs.
During the field inspection, no valid trade license was found, and so the mobile shop was removed by the enforcement month, and the same is currently kept in DIV around of the GMC.
There was no notice served prior to this, Your Honor. No intimation given to the petitioners. And only verbal instruction of the additional secretary to the government of Assam Department of Housing and Urban Affairs. This entire incident.
This was located inside the,
Yes, Your
it's
Honor.
a personal property.
Yes, no problem. Your Honor, I have submitted the Zamabandi, it is annexer 1.
No, without a trade license, you demolish.
Lordship, one,
How many places you have demolished?
Lordship, one workout estate is there. One room has been given on rent to the tenant, Lordship, petitioner number 3. He,
Understood, but is it within the private property of the respondent petition number 1?
petitioner number 1, gave it to petitioner number 3.
What do you mean? It's a
Three.
private property of the petitioner number 1.
Workout estate. He is the Mutation.
What do you mean? It's a private property of the petitioner number 1. It's a work of state.
Yes, Lord.
Okay. Now, if that be so, do you, as somebody does not have a trade license, do you demolish it?
Not demolished. It has been removed, Lord.
Remove? It is being demolished.
So the movable shop was removed by the
Page number
enforcement branch of GMC. same is
57 and
currently
58
kept.
are of photographs, Your Honor.
Page 54, Lord.
The entire thing has been removed.
57, do you have removed
58.
without a notice? How is it possible? And at the instance of some additional secretary, what business does he have? Housing and Avia. Who's the additional
So who
secretary?
is the parent department? Lord? So who is the parent
Whether
department?
who is he? Can he by verbally say,
That
does your GMC work in that manner?
Lord, that instruction I have to take.
Yeah.
On what basis he issued that instruction?
You restore it. If you have done it, you restore it. We'll have it on Monday. Get your instructions. Issue notice making it returnable on. We have it on 18th. 18/9/2024.
When is
Pushta. Who appears for GDD?
CDD Lord Span?
Mr. P. Nayak appears on behalf of the respondent number 1, 2, 3, 4,
Up to 5 lots.
and 5 also.
Yes.
And
it's a
5.
double.
Who appears for the walk-off?
Okay.
Why you are making the walk-off a party?
Because, Your Honor, sir, as per the Waqf Act, in every petition that is been filed by a Waqf property, Waqf estate is required to be made a party, Your Honor.
In a writ petition also.
That has not been specified, Your Honor, but
Does the walk-off act conceptualize anything about filing a writ petition?
no.
Then?
But since it's a Waqf
Isn't
property,
it your case against the GMC?
yes, it's only
Then-
the GMC. We have no grievances against the Waqf property.
1 to 5. Push. This court, for the time being, is not inclined to issue notice upon the respondent number 6. Push. The case of the petitioner herein is that the petitioner, number 1, is a walk-off, is the Anwaruddin walk-off estate registered under the provisions of the Assam. That's registered under what provision?
Yes, sir, Your Honor. It is registered on the Waqf Act, Your Honor.
Which one?
Waqf Act 1952.
Registered under the provisions of the Waqf Act 1956. The petitioner number 1, number 2 is the mutuali of the petitioner number 1. Full stop. The petitioner number 2 had set out a kiosk in the property belonging to the petitioner number 1. And the same was leased out to the petitioner number 3. Did it?
Yes, sir. Yes, sir. The tenancy agreement is annexure number 4, Your Honor.
it is the specific case of the petitioner that the respondent authorities have forcefully removed the kiosk, that too without issuance of any notice. The learned counsel appearing on behalf of the petitioner submits that the collector, Guwahati Municipal Corporation, had also issued a communication to the petitioner number 2, informing that upon verbal instructions of the additional secretary to the government of Assam, Department of Housing and Urban Administration,
Urban affair. Housing
Urban
and urban affairs.
Affairs, the said action was taken. Pusto. This court, the learned counsel further submits that not only a notice has been issued prior to taking such action, but there was also, but the ground which have been assigned in the said communication is that the petitioner number 3 did not have a valid trade license. Pusto. This court have inquired with Mr. P. Naik, the learned counsel appearing on behalf of the respondent number 1 to 5, as to whether the respondent authorities in the GMC can act merely on verbal instructions of any other authority, or if there is a requirement of issuance of any specific order in writing. This court further inquired as to whether the commissioner, whether the respondent authorities in the GMC have the power to remove a movable shop on the ground of there being no valid trade license. The learned counsel appearing on behalf of the GMC submits, the respondent number 1 to 5 submits that he will obtain the necessary instructions. Let these instructions be placed before this court on 18/9/2024.
So there's an interim period.
Why do you require?
The person who is running the shop, Your Honor, his goods were inside the kiosk. It's already all being removed and they were.
The learned counsel appearing on behalf of the petitioner submits that there is an interim prayer for removal of those goods which were lying inside the kiosk. For the present, this court is not inclined to pass such any order in that respect. However, it is made clear that if it is found that the action of the respondents were not in consonance with law, this court would pass appropriate orders for compensation in respect to the goods which have been destroyed on account of the illegal actions of the respondents. Liberty, however, is given to the respondent numbers 1 to 5 to permit the petitioner to take back the goods. Yes, Mr. Bora.
Lordship, this is a method wherein page 28 is an impugn order. Nunia community has been removed from the central list and placed under the OBC list, Lordship. What has happened, Lordship, at
To
page
declare the exclusion of the petitioner Munia from the Tea Garden labor community under the MOBC list from the central list of OBC published by Gazette number so-and-so and inclusion of so-and-so in a separate list. Yes, what has happened?
Lordship, at page 22. Lordship would see at page 21 is the Gazette notification, Lordship. It is typed out. At page 18, Lordship,
This is a notification under what?
what has happened, pursuant to the judgment of Indra Sahani, a committee was made. A committee made a list of communities which were common to both the lists. Our names were there in the Mandal Commission list also, state list also. But you would find that at page 22, at serial number 24,
Hmm.
serial number 24, what you would see tea garden laborers, tea
Where,
garden
where?
tribes, ex tea garden,
Page 22, tea garden labor,
tea garden laborers, 24.
tea, golden tribe, X tribe, so and so. Yes.
Lordship will turn the page and page 23. At subtribe subclause 75, that is the Nunia community.
Hmm.
Therefore, we have included, Lordship peruses page 21, we are included by in pursuant to the judgment of Indra Sahani. Thereafter, there was an expert committee. Thereafter, we were included, including all the states. Now, what has happened, and the National Backward Classes Commission was given the jurisdiction that if there is any tinkering with the list, they should hear the complaints about inclusion or exclusion. Without hearing us, Lordship, now we have been placed under the OBC list at serial number 34, Lordship. Lordship would find that at page 28.
Earlier you were what?
More OBC under the tea garden tribe, more MOBC means more other backward classes.
Earlier you were more other backward classes.
Due to
Huh?
our occupation, Lordship.
Where?
Lordship would see it's a
The government of India has considered the judgment of so and so relaxation of
May I
57%. For the purpose of the aforesaid reservation as per the order of so and so will comprise in the first phase the caste and year which are common to both the lists in the report of the Mandal Commission. The expert body on the creamy layer headed by Justice so and so was commissioned on so and so. Common list prepared by the committee have accepted by the government have decided to notify the next list of other backward classes in the context of implementation of the list. So this is OBC,
Lordship,
list of states of OBCs.
under the tea garden community, that is the more other backward classes.
How do you say more other backward
Well,
classes? They are OBC as per this list.
That's certificate.
10th of
Lordship,
September 2000.
but now what has happened, we are withdrawn from all the tea garden benefits. Lordship, we are not issued any certificate for tea garden, Lordship. Now we have been excluded from the list.
Why?
Lordship, because of this notification data at page 28, on the recommendation of Assam Backward Classes Commission, it has said.
Where? Now these 24, these people are there. So this is a type copy.
Lordship,
Annexure
type
2 is what?
Annexure 2, Lordship, Lordship would find this list, we found it from the internet, Lordship.
What?
But this is a gazette notification at
In
page
pursuant to the
21.
recommendation made by the Assam Backward Classes Commission and in continuation of the demand, the government is pleased to enlist Nunia at serial number in the list of OBC. There? What is wrong?
Now, Lordship would see page 29. And now the Assam Sah Janajoti Jatiya Mahasabha, these are as per them also. Now they don't consider us as a tea tribe, Lordship.
Why?
Lordship, that is our grievance. This is done, Lordship, there is a procedure to do it as per the Assam Backward Classes Commission Act also.
What is that?
Act. May I? At section 9. Yeah.
But these were not followed.
Lordship, no hearing, no request, Lordship.
Did you approach them?
Lordship, now
Whom they will give the hearing? Huh? Who are you? To you. There is only one person in the Nunia community. I'm asking.
No, there are other persons also.
Then whom should they give hearing?
Lordship, they should give any public notice, Lordship, and moreover, Lordship, what has happened, it has done only on the recommendation of the Assam Backward Classes
Yes,
Commission.
Mr. Ardhor, where is he? Plain tribes. Scheduled caste. Directorate of Welfare and Scheduled Caste, backward class. Government of Assam, Social Justice and Empowerment. All these are under Ardhor, isn't it, Mr. Nayak? Huh? Now, all these are under him. Where is he? You have not served him a copy.
No, we cannot find it outside.
You have not served him, most probably.
All,
Because he will be appearing for all these people, except number 9.
yes.
1 and 7.
Huh? You are appearing for 1 and 7. You are appearing. Others are, I think Mr. Dhor can appear, except 9. Mr. Naik, did you see Mr. Dhor around in the corridors today? He's here now in the court. I'll say that he has accepted notice on behalf of issue notice making it returnable on 13th of November 2024. Full stop. Mr. So-and-so or the MRO Digari. MRO Digari appears on behalf of the respondent number 1 and 7. Mr. Ardhor, the learned counsel, appears on behalf of he appears for social justice also.
Yes, I have given copies earlier.
Because all whatever happened to WPT and all these things, every 3 departments he has. Huh?
They bifurcated, Lordship.
Yes, it has been trifurcated, including the board also he appears. That thing. RM Das.
RM Das is also there, Lord.
RM Das is there today. Did you see him? Huh? Now, did you see him today in the court? But Ardhor is there, na?
Ardhor is there. Ardhor
Okay.
also can.
Mr. Ardhor appears on behalf of the respondent number 2, 3, 4, 5, 6, and 8. Stop. Taking into account that the respondent numbers 1 to 8 are duly represented, extra copies of the petition be served upon the learned counsels during the course of the day. As regards the respondent number 9, the petitioner is directed to take steps by way of registered as well as usual. Stop. The petitioner herein claims to be a member of the NUNIA, NUNIA community, which is a subcategorized as a tea garden labor community under the MOBC category in the central list of OBC for the state of Assam. The petitioner is aggrieved by the decision of by the issuance of the notification dated 23/8/2023, wherein the NUNIA community have been put at serial number 34 in the list of OBC of Assam. Mr. B.P. Bora, the learned counsel appearing on behalf of the petitioner, submits that in view of this notification dated 23/8/2023, the petitioners who were otherwise enjoying the various benefits as a tea tribe have been excluded from such enjoyment. The respondents shall bring on record their steps, their stand by filing their affidavit on or before the next stage.
Wait, is a Lordship.
Yes, what are this?
Well, a petitioner before Lordship, my Lord, is aggrieved, my Lord, had not registering her affair, my Lord, was before the official instance, my Lord, yes, my Lord. Her petitioner had lost an affair, my Lord, on 8/8/8.
Yes, why are you coming before this court?
My Lord, she had already approached, my Lord, the SP also, my Lord, as well as DIG also.
Huh?
She had subsequently approached the SP as well as DIG also, my Lord.
Then
They are not taking any action, madam. Only
Then-
SP. They are, madam, only SP had declared that.
There is
that
already a general diary, details
Yes,
have
yes.
been given.
they are the-
On registration of the SR to the district commissioner. Where, for superintendent, this case is under inquiry by the government, what is GO?
Only government
Once
official.
inquiry report is submitted by the authority concerned, necessary action will be taken, superintendent of police. So this is, they are looking into it.
Madam, it is file, madam, one, madam, 8/5/2024.
Threat to my life and threat to my family members continuing mental health are forcing me to appear on the brink of suicide from the NCA. Who is doing all these things?
Madam, it has been done by the receiver.
What is, where is your FIR? Let's see.
FIR is a page, madam. Page. Page 12,
You are a circle officer.
madam. Circle of them.
Circle officer filing an FIR against the district commissioner.
Madam.
Oh. Then,
Madam, any, madam, subsequently she was placed under suspension. That is separate thing, madam. Madam, subsequent present situation, madam, has become more worsened, madam.
since I
nowadays,
failed
madam,
to
every day,
attain
madam,
unsafe,
newspapers are
therefore,
published, madam.
husband and I rushed towards PS to report about the incident. Recently, DC man sent a PN to my rented house at Bhopal to serve an explanation letter on my. The address of my rented house is not available in my hotel. What is wrong?
Madam, now, madam, the petitioner's husband, madam, who is a deputy registrar, madam, of an university, madam, he had also been entangled, madam. Now. the DC
Later
has
on,
been
she
issuing
told me
notice.
not to record and I ended the video thinking, oh, this is a serious case by you. What are you doing?
Madam, because there is a, sir.
You talk with the DC, go there and then the videographer.
Madam, kindly see, madam, the time of the occurrence of the offense, madam, the affair was lost at 2 AM, madam, in the night. Madam, petitioner had to leave the, madam, control room, madam. And the compelling situation, madam.
Owing to your kind notice, I've been facing extreme mental harassment from around so and so. When I expressed my intent to procure 62 gamosas from the freedom fighters and NO case, which were earlier procured by the DC. I was constantly being scrutinized by her with malafide intention to fix blame on me. Again, when I withdrew my petition, I was harassed with another letter reply to which was given command. Today, date of poll, I was entrusted with the responsibility in the issue and received counter of Iman, and the order was issued in the share over Iman. We were not briefed about anything about who were dealing with the labor management, etc. On the P1 day, they did Iman I entrusted with the responsibility and so on. After some time in the material of only on 7 polling stations of so and so were to be collected after 1 PM. Came and humiliated me and used slang words in front of the officials. She tried to humiliate me on the ground that the trunks were still not taken to the designated places of the laborers. I said that unavailability of labor at 1 AM was beyond my control and she kept abusing me verbally. After that purpose, Mr. PA to Ria was sent to the counter at so and so. Since I understood that the man may again try to fix blame on me. What case is this?
Madam, kindly.
This is a case of issuance of rule to be taken up in sometime in 2000 next elections. You should be immediately transferred from there. This is not done. What is all these things you have done? I continue to record her because look at your allegations. I felt that it would affect my career. Therefore, I tried to record that situation was similar in the counters of other LACs. Then ma'am again stepped into the counter of 42 LAC and started to inspect. I was right behind her. I did not want to record her videos, but she tried to humiliate me calling madam, madam. Therefore, I continued to record her because I had to keep proof of the harassment inflicted on me by DC men. I tried to end the conversation on several occasions by saying thank you, etc. But she continuously kept questioning. Later, she told me not to record, and I ended the video thinking I shall drag the trunks myself with the help of other officials. But she kept coming closer to me, and at one point of her hand was almost touching my phone, attempting to snatch it. Since she was always carries weapons, goodness, limits.
My lord,
Yeah.
it is a fact, my
It
lord.
is better than an Alfred Hitchcock story. Yes, Mr. J. Hendrik, what do you have to say? Huh? What is the offense made of? Tell me. What is the offense made of? We quash this immediately. What is this?
Lord,
What offense is made out? This is an irresponsible act on your part to file all these type of things. Why we should not ask the who will be the officer? Revenue? Principal Secretary to the Government of Revenue. Why haven't you made the home, the Revenue Department? Why shouldn't we ask the Revenue Department to take steps against you?
my lord,
This is the departmental action against
my
you.
lord, petition has been already placed on a suspension, my lord.
We should ask the departmental actions.
Now, my lord.
Then what did you sue? Since she always carry weapons, the DC carries weapons. And she openly speaks about it. I told ma'am that she cannot touch my phone in an unauthorized manner. And I literally fled away from the counters of 40 Tihu LAC. The CCTV images may please be checked to confirm the fact. I was also scared that she might harm me with her weapon. I immediately called my husband and told him to pick up from Godown. I was scared and helpless that my colleagues from the administration or EA may not be able to help me in such position. I rushed to Godown, conveniently hid my mobile inside my leggings pocket. I felt as if someone was running from behind me towards me. I met some familiar polling officials in Godown today and requested them to just stay them with me for a few minutes. Since I felt threatened, unsafe, therefore, husband and I rushed toward Nalbari PS to report about the incident. Recently, DC ma'am sent her peon to my rented house in Bazar to serve an explanation letter to me at 8:30 p.m. one evening. The address of my rented house is not available in my official documents. My 3.5-year-old daughter stays there alone whole day with her nanny. Since she could send her peon to send an explanation letter of one night, it may be mentioned that I was available when on WhatsApp that day. She might attempt to send other people now to snatch my phone. My goodness. Go there, 156.3. A learned counsel appearing on behalf of the petitioner submits that taking into account the judgment of the Supreme Court in the case of State of UP versus Akira Basu reported in 2008 to SCC 482, he would not like to press the instant petition. Rather, he would avail remedies under the extant law by approaching the jurisdictional magistrate against if the petitioner is aggrieved by the non-registration of the farm. In view of the above, the instant petition stands closed on withdrawal. Liberty, however, is given to the petitioner to avail other remedies as available under.
Petitioner before a lordship matter is seeking a direction to the respondent authorities matter to take necessary action against the private respondent. What when, my lord, the private respondents set fire the houses of the petitioner and previously hurt the family members of the petitioner, my lord. Thereafter, FIR was filed, that was not registered, Accordingly, I have submitted an representation before the SP, my lord. That was registered, my lord.
Now you want a writ that they should be arrested.
Not only the arresting, my lord, but security, my lord, life and
A
property of the.
security to be given is a different thing from saying that you want somebody to be arrested. Wouldn't that amount to interfering with the investigation?
That is not my primary prayer, my lord. That
Your
is not,
primary prayer is there only. Where's your any other prayer? Should not be issued to direct the official as well, more particularly the officer in charge to arrest the main accused immediately for protection of the member petitioner and in terms of who is threatening the family and his family and on going through the perusal soil. This is your prayer.
my lord.
Then why should this court issue a writ to arrest?
My lord,
What do you
happened, my
say
lord?
about the judgment of the Supreme Court way back in 1970? What is that? State of AF, State of UP was S.N. Sharma.
Probably, my lord, in that case, my lord,
It is not the business of this court to
that
do all this.
petitioner was not the informant, my lord.
Huh?
In this case, my lord, I am the informant, my lord.
Understood. You want some protection, you have asked for protection. That is a different aspect of the matter.
My lord.
But how can this court direct the police kindly arrest these people?
That mass protection, my lord, lordship, maybe please, my lord.
Why should I give? You are not asked.
That is asked, my lord.
You are not asked. You say that arrest him for my protection. That is not the business of
Lordship may always, my lord, mold the prayer, my lord.
molding. Not necessary.
Kindly, my lord, kindly that mass protection.
First of all, you have to approach these authorities. Did you
Authority, I have approached, my lord.
that you should be given protection. Where is it? Where have you approached them? Why should this court give you this?
That is, my lord, I have approached the SP, my lord.
For what? For a recording an FIR, registering an FIR.
First of all, my lord, the OC did not register the FIR. Thereafter, page 11, my lord, I have approached the SP, my lord.
Understood. You approach the SP,
That was converted to a FIR, my lord.
then,
My lord.
so then thereafter,
Now, my lord, the two have been arrested, my lord. And the other two is roaming around my houses, my lord, threatening every day.
so ask the police. Ask the magistrate out there. Magistrate can very well direct these people that why are you not arrested? Or why, what is the investigation they are fearing? You have not approached. Ask the, go ahead and ask the SP now. They are threatening my life. Protect me.
But 2 times their bail petition has been rejected by this court, my lord. Till then, my lord, not arrested, my lord. That much observation, my lord.
What? What observation?
I will file an application before the SP, my lord. That may be considered.
You file. Should I say something which is not born? There has to be a birth of something. Then
May mold the prayer, my lord.
mold, there is no molding of the prayer. The prayer seems to be that you are asking somebody to be arrested. How do I pass an order to that effect?
Because of my lord, they are threatening my life and property, my lord.
Understood. Where have you approached the police that they are threatening you? Show me. You have not. So do I look like a police inspector?
No, my lord.
Then approach the authority if there is a threat.
My lord.
Dismiss.
Close, my lord. Dismiss will harm the representation, my lord.
The learned counsel appearing on behalf of the petitioner, Mr. T.K. Bhuya, submits that the petitioner would be well advised to approach the concerned officer in charge as well as concerned officer in charge and the investigating officer of Kharupeta PS number 45/2020 order superintendent of police Dorong Moldoi in the circumstance the petitioner is being threatened by the accused of the said case so registered. He therefore submits that he would not like to press the instant petition to stay. However, the counsel submits that the withdrawal of the instant petition should not preclude the petitioner to avail other remedies. Taking into account the above, the instant petition stands closed on withdrawal. Liberty, however, is there for the petitioner to approach the investigating officer of Kharupeta PS case number 45/2024 or even the superintendent of police Dorong Mogoldoi in the circumstance the petitioner feels threatened with the actions of the accused persons. Also, in addition to that, the petitioner can also very well approach the concerned jurisdictional magistrate in terms of, this is after 17? 17 after 17?
Before 17, my lord, incident before 17.
A jurisdictional magistrate under the extant law seeking investigation and seeking proper investigation into the said police case.
Develop.
6.
This case is against the demolition notice, page 49. Under section 27(1).
Demolition notice or eviction notice?
Demolition, eviction, my lord, they are going to demolish my house, my lord,
Why?
because house was constructed. My lord, house was constructed above the old construction, Assam type house, without elite, my lord, permission.
Then
Then, my lord,
where is your notice?
notice is on 49, page 49,
Page 49.
my lord. On the basis of a complaint.
And against 2/4/2024, you submitted your reply?
Reply is, my lord, on,
Page
page
3rd of July,
51,
then 2nd of September,
my lord.
then 3rd of September,
Last
prayer
week
for
was finalized.
measurement. Then, where's the order? Order is where? There is no order till now.
My lord.
Then, why are you approaching this court?
There is no order, but they come to the, come to with police administration, which is stated in the petition itself, my lord.
Huh?
On 2/9. They come to the, my premises to demolish my house, my lord, with the help of police administration on 2/9 to 2024, without order.
Then, demolish.
So they don't demolish, I just.
How?
request
How
them-
did you save? Means, give us also the idea.
I request them, my lord, they. I just,
Did you ask them about the order being passed?
my lord, I asked them.
Then they
My-
said
my-
some order has
My
been passed.
mother, my mother, old mother is in the house, my lord. There is no order, there is nothing showing me, my lord. My mother, I was in duty, my lord. When I go there, I request them, they leave the premises. Now, my lord, my limited prayer is issue the notice and, my lord, kindly, direct the GMC not to receive action against the said notice. There is no order. If there is order, then I will come with the order.
Now, what did you do? With due respect, I would like to submit
I-
one Quebecois has been filing complaint against me stating that I have built the RCC Assam type without prior permission. It has come apart from that, Imani. I have already stated in my reply. There, did you ask for regularization?
Yes,
Where is your application for prayer for remeasurement of the constructed earth for existing payment of house tax? Where is it?
first, my lord, I am, asked for remeasurement of the plot, my lord. Then,
Where is your application asking for compounding?
in every application, my lord,
Huh? Nothing.
I was paid for remeasurement. My lord, kindly see page 43, my lord.
Hmm?
43, the reply of previous notice, my lord. Page 43, and it's a 5.
Now I hereby declare that I intend to apply for regularized permission as per the building guide. Then what happened?
Then,
Did you apply?
then, my lord, I asked for, mapping, my lord, and,
Did you apply for regularization or not?
yes, yes.
Where?
there is another issue, my lord. I apply for,
You are just coming up like one after another, one issue. Your basic thing was a notice and stay. Now you say about something more. Then you say about regularization. You declare that you want. But have you brought into effect what was your declaration?
my lord, I will apply as soon as possible.
Then why have you not applied? That was long time back. What are they going to do? Didn't you see in item number 2 what they did?
My lord.
You were you are very you are in a very good position. They issued notice, you submitted reply, then they have not passed an order till now, and they have come. Then you come up and say that, look here, kindly don't do it on 2/9. They go back. We are on 14/9, 13/9. Then also nothing has been done. See the kindness of the GMC. You should be thankful to them.
Well, therefore, request, my lord, I
That
plead-
is why I asked you, how did you, how were you possible? Means how could you do that?
my lord, I immediately apply for the regularization.
Where? Where is your statement?
I will soon, my lord, apply the regularization. Because, my lord, I was so busy, my mother was in the cancer patient, my lord. I was busy with her, my lord. And,
I have due sympathy for that, but the fact that law is law, you can't help it. You
therefore,
are required to take permission and then construct. If you have constructed without permission, they will take its course.
it's a construction, my lord, above the old construction, my lord. You see, that was made on 1993.
So you already have that. Where is your photograph of your building? Let us see.
With the petition itself.
Yes. This annexure 3.
Yes, yes.
And what's your earlier building which was there assessed to the GMC?
No, my lord, then, my lord.
So how do we know that there was at all a building?
It was in
And
Sadgaon.
where was your earlier permission?
Actually, my lord, it was in Sadgaon area. There is, previously there is no GMC.
So
area.
where did you have a permission earlier also? No.
At the time of construction, of my old house, there is no GMC area of my Sadgaon. Sadgaon is not under the GMC.
Now it is under GMC.
Under the
When?
It was, my lord,
It's under GMC, but let them show the earlier permission from the Gaura lots.
Gaubra.
Whatever it is.
So that
there is a Assam type house, my lord.
Assam type was no
Assam
required
type
permission.
in Assam type house of rural area, there is no need of any Gaura permission, my lord. As for mine only.
Lordship, may kindly see page 42. This is the first notice, Lordship. One complaint was received from one Pralukta Das, and on the basis of which notice was issued, directing her to place the no objection certificate, approved plan, etc.
See your reply, annexure 5. Today I'm getting very strange matters. The other matter was another. Here, see what you have written. Yes, read it. I have very less matters today.
With reference to the subject cited above, I would like to bring to your notice that if the plot of land under so was purchased and duly registered on so at the time of purchase of the plot, the print of the buildings in question was already in existence. I being unaware of the fact of the building, Assam type required permission, completed the remaining portion of the dwelling house after repairing the plot of the land in question. However, I also beg to state that the required
You
plot-
purchased in the year 2007.
that-
No, wait. At that point of time, Satgaon was GMC.
2007.
Then how do you help it?
My lord, I was purchased the plot as per agreement, my lord, Elixir 1 on 1993.
Mr. Counsel, you should prepare your matter better. In the building bylaws, you will look into it. There is a scope of asking for compounding. Look into it. So there is a provision that if in a case that it is not unsafe or something to that effect, you can apply for that. Why don't you do that? Who is going to help you out with all these things?
It's important, Lordship, this notice was issued to one Sabera Khatun,
Huh?
not the petitioner.
Sobara Khatun is my mother. My
It
lord.
matter. No, therefore it is, all these are given to both.
That is the issue, Lordship. Problem is, Lordship, when GMC officials went there to his
Now kindly
place,
come to
Lordship,
annexure 9, it is given to
Yes,
two
Lordship.
persons.
misbehave, Lordship. He threatens the authorities by saying that my son is a High Court employee,
Who?
the petitioner.
High Court employee.
Colgate employee.
So that is the
Oh.
reason, Lordship.
That is how they were left away. No, no,
They are
no,
not
no.
taking any action only because of that threatening, Lordship. He is working in he is a High Court employee. Let us not do anything. That is the,
You cannot do that, Mr. Counsel.
and that is why mother is not before your Lordship. The son is here. No notice was issued to the son.
No, this order was issued to the son, na? Fellowship annexure 9. Sabira Khatun and Nasiruddin.
Petitioner is Arif.
Huh? Petitioner name is what? Arif
Yes,
Ahmed is
Arif.
who?
Arif
And who is Nasiruddin?
Nasiruddin is my neighbor.
Why this notice is issued to both persons?
He also made my lord.
Probably
Although it
complaint
is
was
seen that
against-
Sabira Khatun occupies house number 49, Nasiruddin 50. Sabira misbehaved and did not allow the officials from ER to take the necessary measurement. Wife refused to cooperate with ER. Under such notice was issued to prove. That
I immediately, my lord, on 3rd July, I request to them with coming to the office, my lord, meet the commissioner and ask, send someone to my lord. My mother was alone at the house, my lord, on that day. How can she allow to enter the, they don't show even, my lord, any ID that we are coming from the GMC.
and why you are filing the writ petition?
Because, my lord, my mother cannot come to the High Court. Previously, I was filing with the name of my mother, my lord. But recently, some rule was passed, my lord, that the petitioner herself come and sign the affidavit itself. But my mother cannot come, my lord. Therefore, I filed with the statement. And both are in the same, my lord, name in the document. And also, my lord, Brahmapundi is in both the name, my lord, my name and my mother name. And we are the only legal heir of the my father.
But why haven't you not applied for regularization?
I am applying, my lord.
No, you have not.
Certainly, my lord, as early as possible, I will apply, my lord. That was stated in the application, reply of the application. itself.
No, no. You don't have permission. How will this give you any protection? Tell me. You are not making out the case which you should have made out. You should have made out the proper case. Have you ever come across a building bylaw regulations, Guwahati building bylaws regulation? Have you seen it? Have you seen it? No. Then why you are preparing your matter in this manner? You are doing disservice to your client. But unless you seek for regularization, how will this court protect you? Tell me. This court is not going to do it. I can only say to the effect that without an order being passed under 337, no, there should not be any demolition. That's all. But if the order is passed, they will demolish it. Mr. Naik, that's the only order I can pass at
That
best.
line is already there at page 49, Lordship.
page?
49, annexure 9.
No, therefore here it says, here he has been asked to demand. Show cause.
In response to this notice, Lordship, they furnished some.
The petition is submitted. So
Yes.
there is a requirement of passing an order there.
Yes, on the basis of those explanations, authority will pass on.
So without passing that order, you cannot.
Yes.
So that is the limited scope I can only say. But if that order is passed, it will be demolished. There's no way out.
In between, I'll file.
Huh?
In between, I'll file for the regular.
I'm not going to, why should I suggest anything? Laho. Issue notice making it returnable on 39/2024. Mr. J. appears on behalf of the respondent number 1,
1, 6 and 7. Lord.
6 and 7. Why are you making these people a party? Unnecessarily again.
1 and 2. Lord. 2 also. Lord.
1,
6
2,
and 7.
6 and 7. Mr. P. Nayak appears on behalf of the respondent number 3, 4 and 5. So, as the respondents are duly represented, extra copies of the petition be served upon them during the course of the day. First, it is the case of the petitioner that the petitioner is the petitioner had constructed it is the case of the petitioner that in the year 2007, after purchase of the land in question, the land by the deed of sale bearing deed number
In my annexure 1,
huh?
annexure 1,
By the after purchasing the land
it is 18. Actually, it was deed mail in my father name,
purchasing the land in the year 2007,
not exactly.
which had wherein there was a plinth, wherein a plinth of the house was constructed, already constructed upon. The petitioner thereupon constructed the said building, or said Assam type house, that too without any permission taken from the authorities concerned. First, this aspect of the matter is duly admitted, as could be seen from the reply so submitted by the petitioner to the associate planner. Assistant Town Planner dated 21/1/2024. Be that as it may, a notice was issued on 2/4/2024 notice was issued to the mother of the petitioner along with another Nasiruddin by the Commissioner GMC in exercise of the powers under section 337(1) and 2 of the Guwahati Municipal Corporation Act 1971, for short the Act of 1971. The petitioner thereupon submitted various replies on 3rd of July 2024 as well as on 2nd of September 2024. Be that as it may, on 2nd of September 2024, certain officials from the GMC had come to the petitioner's house to demolish. However, at the request of the petitioner as well as his mother, the said demolition did not take place. The learned counsel appearing on behalf of the petitioner submits that the petitioner that no order has till date been passed under section 337(3). Isn't it 3? 337(3), na?
1 and 2, my lord.
No, this is a notice. 337(3). Isn't it 3
Three.
of the Act of 1971? And as such, without passing of such an order, no action of demolition can be resorted to. In addition to that, the learned counsel appearing on behalf of the petitioner submits that the petitioner is taking appropriate steps for seeking regularization. On the other hand, the learned counsel appearing on behalf of the GMC had submitted that the petitioner does not have any permission which is otherwise the requirement of law. Under such circumstances, the action so taken of issuance of a notice on dated 2/4/2024 is in consonance with the provisions of law. He, however, submits that he has no instruction as to whether any order has been passed under section 337(3) of the GMC Act. Full stop. The learned counsel for the GMC further submitted that petitioner admittedly till date have not applied for any regularization, although by his letter to the associate town planner written on 4/1/2024, the petitioner had requested, had submitted that he would submit application for regularization. This court, having heard the learned counsel, is of the opinion that the petitioner is entitled to a limited stay only to the extent is entitled to an interim direction subject to interim directions. Full stop. Accordingly, this court directs that the respondent authorities, more particularly the GMC, shall not carry out any demolition of the petitioner's house until an order is passed under section 337(3) of the Act of 1971. Full stop. The pendency of the instant petition shall not be a bar on the part of the petitioner to approach the respondent authority seeking regularization.
Lords, in the repetition, the Lords may also see one page, Lords, page 22.
What does it say?
Just the one line. This is the Namjari allotment, Lords. Last, this is in vernacular. Beltola Mojar, Hatgaur Moja, so and so, Dui Kotha Matit, Dan or Dokol Hutre, Mohammed Saleh Uddin Ahmed, Pita Gugulpoti Upadhan, Namjari Manjur Kora.
Mohammed?
Mohammed Saleh Ahmed, Pita Gogulpati Upadhyay.
Gokulpati?
Upadhyay.
Where?
My grandfather was Nepali.
But Salahuddin Ahmed is his father, na?
Father is Upadhyay.
Huh?
Father is Upadhyay.
No. See,
His
has
grandfather.
gifted with possession up to part of 2 kathas of land bearing dag number 5, patta number 2, Muhammad Salahuddin Ahmed. Muhammad Salahuddin's father is Gokul Upadhyay. It's a different.
Deeply blessed.
Right.
Let me give us. I'll just make a letter challenge of notification 56 of 23, my lord.
Huh?
Challenge is petition regarding my lord, challenging the notification 56 of 23, my lord.
Oh, same case.
Yes, madam.
17.
Lordship
It is
is
17
17.
order to.
17.
B. Gogoi and Mr. Kayal is there, na?
May please, your lordship. The lordship petitioner's father was GST registered person, my lord. His father died on, my lord, 21/11/20, my lord. And thereafter, my lord, the summary of property was received in the name of the petitioner's father and order was passed in the name of petitioner's father, my lord.
Then,
Lord, basically the proceeding was against dead person, my lord.
huh?
The proceeding was against the dead person, my lord. The proceeding was against the dead person, my lord.
Oh.
His
When did your father die?
father died on 21/11, my lord, 2020, my lord. Dash 20.
13/11.
So-called notice issued on
It was issued on, my lord,
39.
39/23.
When did your father die?
21/11/2020, my lord.
21.
20, my lord. 20,
20.
my lord.
Okay. And who have been filing the returns all this while?
After his death, my lord, son applied for GST cancellation, my lord. He applied for cancellation in 2023, my lord.
Okay, but this is for the period prior to his death.
Yes, my lord.
Now, what will happen if a person dies? His son will be liable, the legal representatives?
Yes, my lord. But my notice and the proceeding should be notice to be issued to a legal heirs, my lord.
Okay. So you have not received this?
My lord, it was uploaded in the portal, my lord, in the name of the petitioner's father, my lord.
Ah.
Thereafter, my lord, it was petitioner sought time for filing reply.
Ah. Who is,
My lord,
so
it was-
who has filed the reply at page 28?
Son, my lord.
Son is what? Signature of the authorized representative, Gopal Das. You have asked for time.
Time, my lord. It was
Then this was again Gopal Chandra Das, SD, proprietor. At page 29, who has given this?
son, my lord.
And what is the son's name?
His name is Siddhartha Das.
Huh?
Siddharth Das.
Okay, so a person who is dead,
Dead.
he signed on page 29.
No, he is not signing. It is written for, my lord.
Huh?
For, continue, lord. You will see for.
Did you ever mention about his death?
It is not mentioned. It is a mistake of the petitioner, my lord.
Why should we interfere?
My lord, thing is that, my lord,
We should not interfere.
what I am proposing, my lord, this notice, my lord,
No interference.
even order is in the name of dead person, my lord.
Order may be against the dead person.
My lord.
But tomorrow what happens? Just for example, you have never stated anything to them
My lord.
that the person had died.
My lord,
The liability will be
no,
yours.
that's why, my lord, what I am praying, my lord. My lord, what I am praying, my lord, a notice to the legal hire, my lord, legal hire will respond, my lord. It is notice, not,
You have never said that. They would have issued it.
now, my lord, it can be issued now also, my lord.
No.
Let me have the instruction, my lord. Otherwise, I could lay hand on my lord on a notification, circular of the my lord, government of India, where my lord, the situation, my lord, when my lord, the sole proprietor expires, then my lord, who will have the benefit of the input tax credit and all, my lord. There it says that it is a legal error, will have to finally, my lord, take the call. And in one case, my lord, decided by the Madras High Court, there also, my lord, in a similar issue, Honorable Court held that, my lord, the so-called will go and the proceeding will go, but my lord, the authority will be at liberty to proceed against the legal errors. Because liability is still there.
Liability will be
Yes.
there.
Yes, ma'am.
No, here is a case where he has never stated. Now, can he take the benefit of this order, which was passed in 2023, and why should this court interfere?
Before issuance of.
Why should this court interfere, Mr. Mishra?
No, madam,
Go there, file appeal.
one thing I'm.
Nothing doing, file appeal. This is not the ground. You have, you say all these things before the appellate tribunal. I'm not going to say anything.
Before issuance of so-called, I have applied for cancellation of GST, madam.
So what? Did you say that the father had died?
That part is not there, madam.
Then you may ask for cancellation, but this is for the period.
My
You applied for later on period. This is for the period from when your father was alive, from July 2017 to March 2018.
My lord.
Then why didn't you say anything? This court does not find it to be a case for entertaining this 226.
My
Go
lord.
there, file appeal. It's not a case for filing. And that too, you are approaching why after all this time?
He was not aware of this legal provision and all, my lord.
Who
Son,
was
my lord.
not allowed?
Son, because he has not inherited the business, my lord.
Give an advertisement in Assam Tribune that
No,
Mr. R.S. Mishra is there to give all the legal help out there. Give it out there. People will come.
No, my lord.
My goodness. Ignorance of law, can that be a
No, madam.
justification?
No.
Then
But my lord, I have made a statement that he has not inherited the business, my lord. He has not inherited the business, my lord. The son has not inherited.
then why you are bothered? It is again the name of the Gopal Das.
But my lord, the department, my lord.
By filing this petition, you are by yourself are you saying? They will ask, they will take up. Why you are bothered?
Department is calling over the phone, my lord. That you pay it all this.
So if they are calling over the phone, you say, I have nothing to do. Let them take action. Why you are filing this petition? The moment you are filing, you are accepting the liability of the father.
Otherwise, of the section 93 says, my lord, section 93, my lord. CGST Act says, otherwise the legal help liable, my lord.
Understood? If he is liable out there, then you have to be liable. File your appeal. You submitted your reply. You never said that he had died.
That was petition mistake, my lord.
Then no case made out. After taking this time also, you did not submit your reply, then why should this court help you? This is not a case for entertaining or
My
dismissing.
lord, only one thing, my lord.
Nothing.
Admitted
There must be liberty
Heard Mr.
to approach this, my lord, appellate authority, my lord, sometime.
Not time, yes, time. File appeal, but this is not the case.
My lord.
4226. Heard Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner. Kuso. And Mr. B. Gogoi appearing on behalf of the respondent numbers 1, 2, and 3. The petitioner herein, who is the son of one Gopal Chandra Das, since deceased, have filed the instant writ petition challenging the order in original dated 30/12/2023 Gusto. The ground assigned, the ground for assailing the said order is that the notice so issued was against Gusto. The brief facts involved is that the father of the petitioner here trade name is there. GST registration is against the trade name. So that trade name is the person concerned.
Yes, my lord, Gopal Chandra
So
Das.
have you inherited or not? That is immaterial. So anybody with this Gopal Chandra Das would be liable.
Yes, in fact, in page 39, Lord, you will see the cancellation of registration pursuant to the application of 21/23, para 4.
Hmm.
This has been issued on 24/7/24.
Hmm.
Para 4. It may be noted that the cancellation of registration shall not affect the liability to pay tax and other dues under this act or to discharge any obligation under this act or the rules made thereunder.
Where is your application?
At page 23, my lord.
Huh?
For cancellation, page 23, my lord.
20?
3, my lord. It is the acknowledgement, my lord, it was submitted online, my lord. Online form was filled up, it was submitted.
Ground? What is your ground?
Lord.
Filed by self. See, page 23 is filed by self.
His son, my petitioner did, my lord, because he has no option, he has to cancel it, because father is no more.
No, filed by self.
Should have been Siddharth, my lord,
Where is the death certificate?
my lord. At page 20, my lord.
Not very legible, Lord, you will see page 21. The date of death is 13/11/20. Not my lord,
Yes, 13, sorry, my lord.
21/11.
13/11.
13/11/20.
13/11. Yes.
I challenge the order dated 30/12/2023, passed under section 73(9) of the CGST Act. CGST Act, na?
Hello, CGS.
Act 2017. The case of the petitioner herein, that the father of the petitioner, namely Gopal Chandra Das, expired, was granted a registration under the CGST Act 2000, granted a registration under the CGST Act 2017 by issuance of a certificate on 9/2017. The registration number, the trade name of the petitioner's father's proprietorship firm was MS Gopal Chandra Das. And the registration number was 18 ADJ PD 878 D1Z8. It is the case of the petitioner that the father of the petitioner expired on 30/11/2020. Full stop. However, a show cause notice was issued on 30/9/2023 in respect to the tax period July 2017 to March 2018 under section 73(1) of the CGST Act 2017. The petitioner thereupon, upon receipt of the same, never intimated the authority that the father of the petitioner had expired. However, on behalf of the father of the petitioner, father of the petitioner, a request was made on 28/10/2023, as well as on 30/10/2023, seeking time to submit the show cause notice by another 15 days. Thereupon, there was no reply so submitted, and the consequent effect was that on 30/12/2023, the impugned order was passed, thereby imposing an amount of rupees 15,74,104 as the outstanding payable to the petitioner, payable by the father of the petitioner to the department. Full stop. After the said order was passed on 30/12/2023, the petitioner has approached this court by filing the instant writ petition on 11th of September 2024. Full stop. It is very pertinent to take note of that against the order dated 30/12/2023, an appeal lies in terms with section
107.
107 of the CGST Act 2017, and the period of filing an appeal is 60 days.
90 days, madam.
90 days. It is a fact that the petitioner knew all the while about the order being passed on 30/12/2023. As the period of limitation have already expired, this court is of the opinion that the limitation is expired. We do one thing. We set aside this and granting you time to file, you give the notice to them,
To the legal house.
to the petition.
Yes, of course. petition.
And because otherwise again, this will happen. It will only delay it, isn't it? This again, we had expired on, so and so passed, order was passed. The petitioner thereupon has filed the instant writ petition challenging the order dated 30/12/2023. From the materials on record, it transpires that the petitioner's father was liable to pay whatever tax was required during the financial year 2017-18, taking into account 18. And in terms with section 96,
93, my lord. 93.
93
93.
of the CGST Act 2017, upon the death of the father, the son would be liable, the legal representatives would be liable. There is no quarrel with the fact that the petitioner's son, petitioner herein, is the son of late Gopal Chandra Das. It is also to be taken note of that had the respondent authorities been informed about the death of the father, they would have accordingly made necessary corrections and not issued the notice to late Gopal Chandra Das, or and would have taken steps for issuance of notice upon the petitioner or other legal representatives of late Gopal Chandra Das. Under such circumstances, as the in-state proceedings was initiated against the dead person, the same has to be construed to be a nullity. And accordingly, this court interferes with both the notice dated 30/9/2023 as well as the impugned order dated 30/12/2023. However, this court is also of the opinion that the period from the date of issuance of the notice dated 30/9/2023 till date be excluded while computing the period of limitation for issuance of, for passing an order under section 7310 of the CGST Act 2017, in view of the fact that the petitioner had only approached this court on 11/9/2024, and there was never any information being provided by the legal representatives of the petitioner, legally of late Gopal Chandra Das, to the respondent authorities. It is also to be taken note of that prior to the death, or even after the death of the late Gopal Chandra Das on 13/11/2020, the petitioner herein, or on behalf of late Gopal Chandra Das, they continued to file the returns. And as such, the respondent authorities were completely unaware about the date of late Gopal Chandra Das. Under such circumstances, this court therefore disposes of the instant petition with the following observations and directions. Number one, the so-called notice dated 30/9/2023 as well as the impugned order dated 30/12/2023 are both set aside and quashed. The liberty is given to the respondent authorities to issue notice, fresh so-called notice, upon the legal representatives of late Gopal Chandra Das in terms with section 93 of the CGST Act 2017. And the period from the date of the said notice dated 30/9/2023 till date be excluded while computing the period of limitation.
Obliged. Lord.
They kept on hold without prior giving any notice. And then I asked to
Your
When-
bank account has been, operation of your bank account has been stopped.
stop.
Why?
Because then when I went to him without giving any assigning any reason to, then I asked to Chief Sagar, then he told that verbally told me that one letter he received from the Punjab National Bank, one from the circle office, Juhat Circle, that is to be held because what happened, my lord? One Mr. Muhammad Nice Rahman was taking the loan. This kind of loan and this one, I was the only guarantor. I was the guarantor. Thereafter, when this borrower, Mr. Rahman, could not pay in time, that possession has already been taken. That building has possession is taken, and the photograph also is there below. Then auction also was been processed. And thereafter, they have sent a letter me on, that is annexed for your lordship statement may go to PNB decision, that is letter. They have sent a letter to me, chief manager, that is my lord, annexure 5. Annexure 5, page 26, my lord. They have sent a letter on 20th August, that is 20 August of 2024. Yes, yes, borrower is unable to decision, though we have taken the position and decision option, is liable, legal action will be taken against you, it is not been there. Okay, fine. But 7 days time also was granted. Even before that, when assuming that before that if I'm fault, they have stopped my account on 24, that's just 4 days after. And thereafter, I have written a letter to chief manager. You give me at least, show me reason why it is he has not furnished. I have sent letter by register post, which is on record, it is he has received it. I have written letter to PNB also. Then you are not.
Who is appearing for PNB?
PNB is appearing, my lord.
My lord, I am appearing for PNB.
What do you say?
My lord,
What
he is
power-
a,
Under what powers you have to ask them not to operate the bank account?
my lord, we issued a notice because he was a guarantor to the loan, my lord.
Then
Then we learned that he is holding a bank account in State Bank of India. So we issued a notice that please put on hold so that we recover our amount, my lord. That was the only limited.
under
Uh,
what provision?
Basically, we have to take instructions from the bank also for
How
one.
can you do that unless you exercise the powers under 13.4? Did you issue a 13.2 notice to him?
No, 32 notice, my lord, no, because he was the guarantor, my lord.
Understood. The guarantor can also be equally liable. It's
My
a
lord.
different thing. But without issuing a 13.2 notice, how can you exercise 13.4 if it is done under the security? Otherwise, do you have the power to ask any bank out there, kindly stop everything, we have get the money? Otherwise, any amount you are to get is either through the court or under the Securitization Act.
My lord.
So how can you do this?
So we'll recall that letter, my lord.
I think you forthwith recall this. And you also appear for State Bank.
No, State Bank.
Yes, we
You
appear
also
for,
appear for State Bank also.
yes, my lord. But in this case, we have not been
We have
assigned.
it on 18th. Mr. Sahewala, we have it on 18th. Inform this court that you have recalled those.
Hello.
This is not done.
Hello.
We'll have it on 18. Ask your clients to do that. But after all, it is a salary account.
Yes.
And
Hello.
you have already recovered whatever amount it is there, you have recovered. Unless you act.
No, not recovered, my lord. We have not recovered. Auction was carried forward, but it did not materialize.
Hmm.
So
It's not material. You have already taken action against them under 13.4 or whatever. But without putting him to notice under 13.2, you can't do that.
Hello.
We'll issue notice making it returnable on 18/9. We expect you to
My
do
lord,
this.
may I
My
appear either on 17th or 19th because my puja
You
is
want
there
your
on
you-
19th
No,
or
Mr.
17th.
Bolwar, do you want your clients really, or is it your personal
No, no,
convenience?
my what happened, my lord, on 17th or 19th, my lord.
17th or 19th, not possible. We'll have it on 18th because this is a matter of urgent nature.
Yes, my lord, then I'll
He
come.
has been.
I'll come,
So
I'll
ask
come.
your junior to be there
Yes, and then I'll come in that case.
or be on video conferencing. This needs
Yes,
to
yes,
be
yes, yes,
recalled.
yeah, definitely, my lord. Sorry, my lord,
You
I'll come.
you think about your
Yes,
client.
yes, definitely, my lord.
Issue notice making it returnable on 18/9/2024. Mr. A.K. Sahewala appears and accepts notice on behalf of the respondent number 1, 2, and 3.
my lord, not one, my lord, not 1, 2, because State Bank has not instructed me. Only on 3, but verbally I'll inform them. Only on 3.
Appears on behalf of the respondent number 3. You take notice on behalf of 1 and
But
2.
I think there will be some kind of chaos, my lord. I'll inform them verbally. If required, we'll appear on for 1 and 2 on the 18th.
Yes. Okay. Accepts and notice on behalf of the respondent number 3. Appears and accepts notice on behalf of the respondent number 3. Mr. A.K. Sahewala further submits that he normally appears for the State Bank of India. He would therefore inform the State Bank of India about the pendency of the instant writ petition. Full stop. This court, for the time being, full stop. The petitioner herein is given the liberty to serve a copy of the notice by way of dusty upon the respondent number 2
Who? I'll-
by way of dusty. Huh?
my lord.
He appears, it's okay. Issue notice making it returnable on 18/9. Mr. A.K. Sahiwala, Learned Counsel, appears and accepts notice on behalf of the respondent number 3. Mr. A.K. Sahiwala, who also in other cases represents the State Bank of India, submitted that he would also duly inform the State Bank of India about the pendency of the instant writ petition. Full stop. Extra copies, 3 extra copies be served upon Mr. A.K. Sahiwala for
Rich.
during the course of the day. The case of the petitioner hearing is that the petitioner was a guarantor in respect to a loan taken by the performer respondent number 4.
Four.
Full stop. It is the specific case of the petitioner that without initiating a notice which is otherwise mandated under law, the respondent authorities, more particularly the State Bank of India, have stopped the operation of the petitioner's bank account at the instance of the respondent number 3. Full stop. This court, during the course of the hearing, inquired with Mr. A.K. Sahiwala whether such a course of action is permissible, taking into account that in order to take such action, either the respondent bank is required to approach the court or initiate actions under the Securitization and Reconstruction Act, and having not been done, and that having admittedly not being done insofar as regards the petitioner herein, could such an action be resorted to? Mr. A.K. Sahiwala submits that he would take appropriate instruction and revert back to this court on the next day. We expect you to tell both of them.
My lord, absolutely.
Thereafter, we'll see what happens.
My lord. I love
Deeply,
that.
obliged. Deeply. obliged.
Copy, who will accept copy? You will accept.
You give the copy to 3
I'll give
copies.
I'll give today.
It's an item 10.
এখন নামটো লিখি ল'ব দেই, Securitization and Reconstruction.
Wait, please, Your Lordship.
Yes.
Lordship, this matter pertains to non-payment of family pension to the petitioner under the scheme of Swatantrata Sainik Sanman Pension Scheme. Lord.
Not a non-amount of family pension.
Family pension. Our father was a freedom fighter. He was a recipient of the said pension. Lordship.
Yes, why haven't you paid?
Lordship, we have written to the petitioner several times that to furnish some documents. Lordship.
That
They
document,
have not furnished the documents.
What are the documents?
Marital status, employment status, source of income, legal.
Where is the document? Is mentioned anywhere in your affidavits? No. Where is your instruction? You are appearing for whom?
1 and 2 rows. On behalf. On serial number 2, Lordship. Report is available.
What are the documents required?
they have asked for annexures 5A.
Tell me, what are the documents required? Show me. Marital status, unemployment status, source of income, including service pension, so and so, to this ministry at the earliest. So these are the documents which you are required. The petitioner have not furnished. Heard miss,
Lordship,
heard miss,
as they.
so and so, appearing on behalf of the petitioner. Mr. So and so appears for respond number 1 and 2.
On behalf of KK Parasol.
No Parasadi. 1 and 2.
Also, I'm for
Mr.
RK Talukdar Lordship.
R.K. Talukde appears for respond number 4. And Mr. B.J. Talukde appears for respond number 3 and 5. United Bank? Okay. 3 and 5. So, the petitioner herein is aggrieved by the delay in sanctioning the family pension to which the petitioner claims to be entitled to under the what?
Swatantrata Sainik Samman Pension Scheme.
Under the
Swatantrata, page 20.
Swatantrata Sainik Samman Pension Scheme. Pusto. The learned counsel appearing on behalf of the respondent number 1 and 2 submitted that that in order to process the said family pension, the petitioner have been requested on various occasions to submit certain documents, which are number 1, marital status, number 2, unemployment status, number 3, source of income bracket, including any service pension from state / central government, if any, bracket close, of Miss Silpi Chakraborty of the petitioner. Number 4, legal heirs certificate, na? Legal heirs certificate of Srimati late Pranoti Rani Chakraborty and late Digendra Chandra Chakraborty. Full stop. He therefore submitted that as these documents have not been placed before the respondent authorities, that is the whom she should give.
Department of Home Affairs.
Huh? To whom?
To respondent number 1 also.
She is going to go there and give it. How is it possible?
No,
Where?
to state government.
Huh?
To state government. From the department.
To whom? Home and political.
Home and political.
Have not submitted those documents to the respondent number 3. No action have been, the respondent numbers 1 and 2 are not in a position to process the claim of the petitioner. Ms. So-and-so appearing on behalf, you have those documents?
Lordship, these documents we have already furnished. Lordship, we come to page 35 once.
Page 35.
This is the second letter she has. The first letter in page 28. She has submitted that she has sent all the required documents on 24/10/2017. And this 35 page number, Lordship, on 22/12/2021, she has again written to the under.
The learned counsel appearing on behalf of the petitioner submits that the said documents were duly submitted on 22/12/2021. Be that as it may, this court is of the opinion that as the submission has been made, the petitioner is directed to submit these documents before the respondent number 3 within 30 days, 15 days from today.
Okay, Lordship, but the Lordship original copy has already been submitted. Scanned copy.
Originals have been submitted.
Yes, this is written in the letter, Lordship, page 35.
Page 35 is scan copies.
She has already submitted the original, which is submitted previously in original.
To the United Bank of India, to
Yes,
you.
Lordship. Now, in this connection, I have submitted the scanned copy of the above mentioned annexure 5A and 7, which
The learned counsel of the petitioner submits that the said documents, the originals of said documents have already been submitted through the United Bank of India Karimganj branch. And as such, On an earlier occasion, the scan copies were submitted on 22/12/2021. Full stop. Taking into account the above, this court directs the petitioner herein to submit within 15 days another set of scan copies in Annexure 5A and 7. Another set of scan copies of the documents referred to herein above within 15 days. Another set of scan copies of the documents referred to herein above within 15 days. To the respondent number 2.
Yes, sir. To state government, it will go.
Huh? To the respondent number 3, to the respondent number 2 routed through the respondent number 3, and be submitted to the respondent number 3, who shall forward it to the respondent number 2. Full stop. List this matter again on 4th of November 2024, on which date the counsels appearing on behalf of the respondent number 1 and 2 shall apprise as regards the status pursuant to furnishing of these documents to the respondent number 3 by the petitioner.
Lordship, this documents, what are the documents? Only annexure 5A and 7 only has been written, and declaration of employment and income certificate. Independent income. But that legal year certificate has not been mentioned in the letters which were furnished.
I mentioned it, legal heir certificate. You get it. Submit.
Obliged.
Item 12.
Affidavit has been sent for vetting. 1 week time may be given, my lord, to file affidavit.
Huh?
1 week time may be given to file affidavit. The affidavit has been sent for vetting. 1 week, my lord. I have already submitted the instruction, my lord, before the court.
This is violation of Article 14. I can't do that. I'll pass the order.
Uh,
You have been given last of time. Taking into account about this court grants 2 weeks time to the relator to file the AR, which failing which this court shall proceed with the disposal of the writ on the basis of the pleadings available.
submitted the instruction, my lord, on the basis of.
I gave you on 21/8. We impose cost.
Kindly 1 week, my lord. Then
50
I
lakhs.
also Friday, my lord.
How much is the total amount you are asking?
25 lakhs,
Okay.
68,000.
Okay, we can impose a cost of 2.5 lakhs.
My lord, kindly on Friday, my lord, or Wednesday, my lord.
2.5 lakhs cost.
My lord, Wednesday, my lord.
No, nothing doing. Otherwise, take this order. We'll pass the order.
The instruction, my lord.
Against that, you go there to the division bench. I pass the order. There's no ground for release. It means you can't keep this money.
Only with Friday, my lord, next Friday.
No,
my lord.
no.
We have received it.
No,
and
no,
we
no,
have,
nothing to-
submitted before the court also,
I'm
my lord.
disposing it off, directing you to pay this. You have any appeal, go there before the division bench. But I'm not going to change my order. The order I have passed. Did you submit the unconditional and unequivocal no claim certificate?
Yes, my lord.
When?
Already, my lord, long back, my lord. Actually, my lord, my final bill was released in 2016.
No,
Final-
I
final,
understood,
lordship,
but
kindly
last
report
time
it.
they said something else.
Yes.
So
my
there
lord,
was
that
an
is-
unconditional and unequivocal no claim.
Yes, my lord. Actually, what happens, my lord,
Where did you submit that document? Show me.
my lord, lordship may kindly see my final bill, that is 42 page 42, my lord. That was final bill, my lord. And lordship, I will show the condition of the tender agreement.
Close, please file
That was
your
final.
with so and so. One bill, MB statement, one case file, one NOC. NOC is what? No claim certificate.
No claim certificate. My
No,
lord,
no,
lordship may
NOC is
kindly
what?
see
Now, what is the NOC? Did you sub?
Please, my lord, may I read one clause, my lord?
Huh?
May I read one clause, my lord? Lordship may kindly see. That NOC was long back submitted, my lord, and on the basis of that, my lord, final bill was released.
Hmm.
Only that security money was not released because, my lord, they have said that audit objection was there. I have submitted one RTI application, and on the basis of the said RTI application, reply
No,
was
no, 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 Mr. Sharma, kindly understand one thing. Where is your no claim certificate which you have submitted?
My lord, lordship may kindly come to page number 14 of my petition. That is the tender clause of the tender agreement, my lord. 35.3.
Shall be returned to the after physical completion of the work and after the expiry of the maintenance after no claim and after passing the based on no claim certificate by the competent authority. So
That was-
you
that-
say that finance bill having already been released,
That means, my lord,
there cannot be a question of no claim certificate.
Yes, my lordship may kindly see that tender agreement. This is
Right.
the tender agreement.
You pass the direction. With interest at 18%.
35.3.
Huh?
35.3. That is the clause, my lord.
Heard Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner, Ms. A. Gayan, the learned counsel appearing on behalf of the respondents. Full stop. The petitioner herein is aggrieved by the inaction on the part of the respondents to release the amount of rupees 25,68,809, which is the security money against the contract agreement number CON/NLR-MZS/1790 dated 7/3/2014. In spite of the fact that the petitioner have completed the said work as far back as on 28/12/2015, isn't it?
My lord.
The facts relevant for the purpose of deciding the instant dispute is that the the petitioner was granted a contract for manufacturing by the NF Railway for manufacturing and supplying of 50 size machine crushed stone ballast on cess/berm of railway embankment and station yards between KM 304 to 340 in between North Lakhimpur to Murgong section. Stop. The Deputy Chief Manager CON/tender NF Railway, while conveying acceptance of the tender of the petitioner, directed the petitioner to commence the work with a further direction to deposit rupees 21,42,759, being the security deposit by letter dated 16/1/2014. Full stop. The petitioner, while submitting his tender, had deposited an amount of rupees 4,26,050 as earnest money. The petitioner was directed by the work order dated 16 to deposit 25,68,809. Yeah, full stop. Under such circumstances, taking into account the deposit of the security money pursuant to the communication dated 16/1/2014 and the earnest money which was lying, the petitioner had deposited an amount of rupees 25,68,809. Full stop. The petitioner duly completed the work on 28/12/2015. And upon being satisfied, the Deputy Chief Manager /CON/3, NF Railway issued certificate of satisfactory completion by the letter dated 15/2/2017, which is enclosed as Annexure 3 to the writ petition. It is also relevant to take note of that the final bill of the petitioner was released long back in the year 2016. And this aspect would be seen from Annexure 5 series. Five G, na?
My lord, page 42, lordship may kindly see page 42 and 43, my lord. This is the final.
From Annexure 5G and 5H
Yes.
of the writ petition. However, in doing so, the amount of rupees 28 lakhs, that's it, huh?
Right.
25 lakhs 68,809, which was lying as a security deposit, have not been released. In spite of various requests so made. The learned counsel appearing on behalf of the petitioner have drawn the attention of this court to clause 35.1,
35.3, madam.
35,
0.3.
35.3 of the, what is this?
Is the
Additional special conditions of the contract, wherein it has been mentioned that before releasing the security deposit, an unconditional and unequivocal no claim certificate from the contractor concerned should be obtained. He therefore submits that as the final bill of the petitioner have already been released, should be obtained. Full stop. Itu na, 31, yeah, 9, 35 have not been released. Being agreed, therefore, the instant writ petition has been filed, seeking a writ in the nature of mandamus, directing the respondent authorities to release the amount of rupees 25 lakhs, along with interest at the rate of 18% per annum. The record reveals that notice was issued on 24/3/2023. Full stop. It is seen on various occasions that the railways have been given opportunity to file their reply, but no reply had been filed. Full stop. On 22/4/2024, this court on 29/7/2024, this court granted an additional opportunity to the respondents to place before this court the instruction by way of an affidavit as to why the amount payable to the petitioner have not been released. It is also made clear that this court further made it very clear, also put the respondent authorities to notice as to why interest should not be directed to be paid if there is a fault on the part of the erring officials in not releasing the this court further put the respondent authorities into notice as to why interest as claimed in the writ petition should not be imposed upon the respondents, and if there is a fault on the part of the erring officials as to why the said interest should not be deducted from the salary of the erring officials. Accordingly, the matter was fixed again on 21/8/2024. The respondent then also did not care to file their affidavit. However, the stand which was taken was that the petitioner amount had not been released in view of non-submission of the unconditional and unequivocal no-claim certificate. In addition to that, there is an audit objection to the final bill. Under such circumstances, this court granted further 2 weeks' time to file their affidavit and directed the matter to be listed today. The respondents, however, still did not care to file the affidavit. First, it is relevant to mention that in the order dated 21/8/2024, this court made it clear that if the respondent failed to file the affidavit, this court shall dispose of the writ petition on the basis of the pleadings available on record. Under such circumstances, this court therefore takes up the writ petition for final disposal. Mr. J. Sharma, the learned counsel, appearing on behalf of the petitioner, drawing reference to clause 35.3 of the additional special conditions of the contract. Additional special conditions of contract submitted that the question of issuance of a passing of the final bill does not arise without the unconditional and unequivocal no claim certificate being furnished. First, he therefore submitted that the instruction which was placed on 21/8/2024 is nothing but to wriggle out of the contractual liability as well as from the statutory as well as the interest to which the respondent railway authorities are bound are liable to pay under law. First, from the above facts, it is very clear that there is no stand taken by the respondent authorities to deny the claim of the petitioners. This court have also taken note of the enclosures wherein the annexures to the writ petition, wherein it has been categorically, it is categorically seen, more particularly from annexure F 5G and 5H, that the final bill have been duly passed. Full stop. It is further seen from annexure 5I to 5K that the respondent authorities have categorically held that the petitioner have duly completed the work in question to the satisfaction of the respondent authorities. These are different works. Now we are concerned with which one? Number 5I. 5I.
Simultaneously, these three works were continuing.
Now you only did 5I.
Yes, yes, 5.
5I, not 5J. 5J is some Sivam trust.
Yes, yes, yes.
And 5H is different, nah?
Different.
Parikshit Das is who?
These three works are.
Who is Parikshit Das?
Parikshit, this is petitioner.
And who is the other one?
Others, simultaneously, these three works were going.
So and more particularly from annexure 5K. 5K na?
5I is Parikshit Das.
5I is not Parikshit Das. Where is it?
Sorry.
It is 5K.
5J.
K.
5, my lord. K is the Parikshit Das, my lord.
5K. Push.
Yes, I'm quoting, my lord. As per the instruction, my lord, the security deposit of the petitioner has already been released on 25/5/2023, and subsequently payment has been received by the petitioner. That is as.
I have no instruction. I have no instruction.
That is the instruction, but it's an instruction.
We pose interest on that. It was done in 2015.
23, my lord. Security deposit has been released on 23, my lord.
So
means
when
after
all
filing
these things have come, why didn't you inform at all these things earlier? So many dates it have gone.
That's why I'm trying to say.
You are not trying to say.
Yes,
On
that's what
earlier dates, when the matter came up, you said
I-
that they
I
have
was
not
absent.
released.
I was absent on that day.
No, no. This
But
way,
it-
whoever is here, I'm not bothered. Therefore, ask nobody
my
to
lord.
appeal.
I was placed that instruction before the court, my lord, on that day, my lord. Written instruction, my lord.
Full stop. From the above, it is therefore clear that the petitioner was entitled to the security deposit. Full stop. During the course of the hearing, Ms. Agayan submitted that the petitioner have already been released the security deposit on
25/2023.
25,
5/2023.
25/5/2023. Full stop. And the petitioner have duly received the said amount. Full stop. It is, however, very surprising to take note of that on earlier occasions when the matter came up before this court, and when the issue involved was specifically only in respect to the security deposit, the respondent railway authorities have never informed this court. It is relevant to take note of that if this date, which the petition, the learned counsel appearing on behalf of the railways states that the amount was released, that is on 25/5/2023. The matter have been, the instant writ petition was listed on 23/6/2023, 15/9/2023, 6/10/2023, 22/4/2024, 29/4/2024, 21 and 21/8/2024. In fact, on the last date, that is on 21/8/2024, it was mentioned that the petitioner's security deposit have not been released on account of non-submission of the unconditional and unequivocal no claim certificate. So this action on the part of the respondent authorities is deprecated, and the general manager, Northeast Frontier Railway, is reprimanded for his conduct. Under such circumstances, in addition to that, this court also reprimands Ms. A. Gayan, the learned counsel appearing on behalf of the railway authorities, taking into account that at the time of taking up the matter, she had sought for an adjournment in spite of the fact that she knew that a payment had been made. Accordingly, this court therefore disposes of the instant writ petition with the following directions. The petitioner herein is entitled to the security deposit of the amount of rupees 25,68,809. If the amount have already been paid, there is no requirement to make any further payment. It is also seen that the petitioner herein was entitled to the amount security deposit with effect from upon completion of his work and after the maintenance period was over. The maintenance period was over on
2 years. From date of completion, 2 years.
28/12/2017. There was no justification shown or placed before this court why there was a delay. This court, however, takes note of clause 35.4, which stipulates that there shall be no interest payable upon the earnest deposit money and security deposit or amounts payable to the contractor under the contract. Under such circumstances, this court would not like to impose any interest as claimed. However, this court is of the opinion that there is a statutory tort committed by the respondent authorities in not granting the dues to the petitioner in due time. Accordingly, this court imposes a cost of rupees 1 lakh upon the respondent authorities, which shall be paid to the petitioner within 1 month, 2 months from the date a certified copy of this order is served upon the general manager NF Railway.
And then I have something, prayer, my part may be, that part may be leave by the CRD, requirement of the GM minus because.
At the conclusion, this court further reprimands Ms. A. Gayan, and this aspect be brought to the notice of the central government about her conduct. If I put that, then don't say. Other part will always remain. Why didn't you say at the first instance that the payment was made?
Apologize for it.
No.
But kindly,
You're gonna black or blue kitabot different likhibo.
Right.
Trust issue has developed with you. You should have said that. Why on first place you said that there's nothing?
You will find the latest status report.
SIT, na? Is unhappy with the investigation so carried out taking into account the respondents hearing, including SS so form, have not been able to trace out the daughter. Okay, this daughter business.
Right.
Yes, what is the
Latest status report we have filed by way of an affidavit. on
affidavit?
11th.
Affidavit has not come on record. Mr. BJ Talukdar, the learned counsel appearing on behalf of the petitioner submits that appearing on behalf of the respondent submits that an affidavit has been filed bringing on record the said status report. So, however, the said affidavit is not a part of the reports. List this matter again on 23rd of September 2024.
So there is IA lordship for implementing the CBA as party respondent. There is an IA I have filed lordship for implementing the CBA as party lordship.
We'll take it up on that.
Yes.
Rules framed under the Assam Land and Revenue Regulations 1886. Ms. A. Talukdar, the learned counsel appearing on behalf of the petitioner, submits that the petitioner was not aware about the cancellation of the land proposal dated 6/8/2024. He further submits that the certificate enclosed as Annexure 5 to the affidavit is in the name of the father of the petitioner. And in terms with the land policy, a person, a son who is residing separately would not come within the ambit of a family. Is that your submission?
Not.
She therefore submits that she may be permitted to submit a reply to the said notice in view of the judgment of this court in the of the division bench of this court in the case of Salakuddin versus State of Assam, reported in 2024 SCC Online SGAU 426. This court have given a due and anxious consideration to the above aspect. Under such have given due consideration to their respective submissions. The question as to whether the petitioner has any bona fide claim or right involved is a question which can be decided by the circle officer who had issued by the circle officer as he have been duly empowered in terms with Rule 3 of the settlement rules. Under such circumstances, it is the opinion of this court that some opportunity be given to the petitioner to approach the circle officer by submitting a representation showing that the petitioner has a bona fide claim of right involved. Accordingly, this court grants 10 days time from today to the petitioner to submit such application to show that the petitioner has a bona fide claim of right involved. The respondents shall duly, the circle officer on such representation shall duly consider the same And
One hearing already took place, Lordship. They have been given, they have written something. That's it, Lord.
Page 37.
Page 37.
oh, no point going.
Page 38, Lordship. Page 38.
No, madam, no point.
Lordship, page 38, they have taken a hearing, but nothing has been communicated regarding our claim, Lordship.
You have no claim.
But they have not stated any reason, Lordship. In the eviction notice, they have not stated any reason. That's why we are.
Or reason for what?
Regarding our eviction, Lordship, because.
They have not
occupied-
stated any reason for eviction, not necessary, because they have already issued you, a
But,
hearing have
uh,
been done.
hearing- Regarding the hearing also,
And
and
it categorically say in your notice, it's a water body.
otherwise then also, Lordship, the SDLEC, that was not known to us earlier.
Submission দুটা লিখি দিলো, তাৰপিছত লেখক. I've heard and given my anxious consideration to the above aspect of the matter. In the opinion of this court, the question of relegating the petitioner now to again submit a representation would be a useless formality, taking into account that the petitioner was issued notice as on 31/7/2024, and the petitioner duly heard before issuing the notice dated 19/8/2024. It is further seen that the land in question is also is a pond, bracket water body. Under such circumstances, the question of granting settlement to the petitioner over the said land does not arise. In addition to that, the petitioner's application for settlement has also been cancelled. Under such circumstances, this court finds no ground to interfere with the order date notice dated 19/8/2024. The respondents would be at liberty to take due action in accordance with law. Before parting with the record, this court, however, observes that the petitioner herein would, in spite of the rejection by the subdivisional land advisory committee, would be at liberty to apply for any other land for settlement, subject to conforming to the mandate of the land policy 2009.
In item 26, the circle officer made a prayer before your lordship that they need some time, lordship. For the certain.
Last occasion, instruction was sought for reversal.
No,
Regarding the
you
field
take
visit.
how much time it is your lookout. I'm not on that. His only allegation is, you see, the settlement, he had filed an application for cancellation of the mutation in favor of him. Now
Regarding that field verification,
is
lordship.
directed to apprise this court on the next date whether the said application seeking cancellation or in favor of the man has been disposed of or not. Now, how do you challenge an order of mutation before the circle officer?
Lordship, it was challenged before the deputy commissioner as an appeal, your lordship. Will find.
Yeah, there the problem is. See, what is this deputy commissioner doing? And then deputy commissioner did what?
Deputy commissioner directed to submit a fresh representation application before the concerned circle.
How? How is it possible?
And
You are asking the deputy commissioner giving a power of review.
It is in page 54, your lordship, it is reflected. Page 54, your lordship. 53 and 54.
How is that, he set aside this? Tell me.
Lordship,
Where's your appeal?
the appeal petition is not annexed over, but.
But order?
Order this one, 53, page 53 or.
Page?
53. Annexer 6, your lordship.
5-3.
Yes, my lord.
Yes. Using the materials, I mean.
Alright.
No. He did not do. What he did,
Yes, my lord.
he asked you to file another application.
Yes, my lord. That
And
it
this
was-
order has attained finality.
And pursuant to this order, my lord, that was filed before the circle officer, your lordship. So far, that petition is pending.
Yes, why you are not disposing it of then?
Lordship may direct. Lordship may, within a time frame, lordship may.
Who is appealing for the other respondent, private respondent?
By giving a
Huh?
hearing for both the parties, lordship, it can be disposed of.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. H. Sharma appears on behalf of the district administration, including the circle officer, Kuntu? Kamalpur Revenue Circle. And Mr. So-and-so appears on behalf of the private respondent. The petitioner herein is aggrieved by the inaction on the part of the circle officer of the Kamalpur Revenue Circle in not disposing of the miscase number, in not disposing of the case. Wait, what is the case number?
It is received at 1169.
Huh?
It is received as 1169.
If you don't have a case number, how is it possible?
Dated 22/8.
No, there is a number.
22, my lord.
Not disposing of the. Hey, that is why this is happening.
It's 54, your lordship.
Don't know what is the case number. Is this the case number 118M? No, this will be. I would like to apprise you the land measuring is found to be in possession of a second party in so and so, the copy of the land. Is this the one? Case number 188M/2021. No. Don't know the case number.
Date is there, my lord, 22.
Can't help it.
22, my lord.
Mr. H. Sharma, the learned counsel appearing on behalf of the district administration 6 for another 2 weeks' time for obtaining instructions. List the matter after 2 weeks. Can't help it. You don't get your case number, and this could have been disposed of. Yes, madam, private car also, governor.
No, my lord, I have received instruction. The commissioner.
I would have understood if it was the other way around. You get it done.
Lordship.
I issued a letter to the district council for permission of conversion of the vehicles so and so from so and so expressing in mutation. So nothing remains.
Lordship, the last paragraph, my lord.
The NIC was requested to furnish the existing workflow in Bahon so and so. The
Yeah,
NIC
but-
authority in his reply said the conversion of commercial. Stated that he is required to update invalid yesterday. No, they have to have a fitness certificate.
Yes, my lord, they have
He
to
will
provide.
get the fitness
My
certificate.
lord,
You were not giving the fitness certificate on the ground that he did not have the year.
SLD.
He will apply for that and submit.
Yes, sir.
He has no objection.
Not, we don't have any objection.
They have to provide all the documents, my lord. They only.
Subject to the condition, lordship, they provide us the,
You say
fitness
you give a
certificate
copy to
without-
him. Applicant start. Applicant comes with necessary assist, generate application number, cashier fee, record verification email, registration AI, approval by DTO, applicant download RC and gets SMS also.
This is the work.
So here in the first paragraph, the secretary has already given,
Yes, sir.
no problem. So your only problem was that.
Fitness
Yes,
certificate.
sir.
is of
The fitness
SLD.
certificate,
Huh?
lordship. The fitness certificate,
You have to provide.
Your only problem was not the fitness survey, the
SLD.
governor.
SLD, yes,
SLD.
sir.
Now that has been taken care of.
Yes, sir.
Now you have to get the fitness certificate.
Yes.
So we just close it on the basis of this. And you produce the fitness certificate and then register it.
Everything is online right now. That's why this is the problem.
Whatever may be,
My lord.
they will do it.
The fitness certificate should be issued, lordship, without insisting upon the SLD.
That is already there, na?
Yes.
The problem is that, my lord, before this vehicle was transport vehicle, but he has not created the SLD. Now the system.
It was
requires-
not required earlier.
Earlier it was not required.
So
Now the
therefore, how will
yes,
you have
yes.
it?
They have taken up the matter with NIC, that's why. my lord.
Whatever may be,
My
you
lord.
cannot.
Lordship,
Because now he wants to convert it
They're
to a
private.
personal one.
my lord may dispose of the matter.
The petitioner herein is agreed, have filed the instant writ petition being aggrieved in not permitting the petitioner to convert his vehicle from tourist cab oblique tourist maxi cab to private, as have been requested by the petitioner by the application number dated 3/10/2023. The sole the two objections which were taken in the said against the said application was that the petitioner did not have the petitioner is required to install a speed limit device, and thereupon a fitness certificate has also to be placed. Today, Ms. M.D. Bora, the learned counsel appearing on behalf of the Transport Department, has placed before this court an instruction along with certain documents. From the said instructions dated 13/9/2024, it transpires that the Secretary State Transport Authority had already issued a communication to the respondent number 4 for granting permission of conversion of the vehicle of the petitioner. Full stop. It has also been mentioned in the said communication that the petitioner's vehicle did not have the fitness certificate of a transport vehicle in view of the fact that the petitioner's vehicle did not comply with the speed rule 118 of the Central Motor Vehicle Rules 1989. As the petitioner's vehicle, while it was a taxi cab transport vehicle, was not fitted with the SLD. Full stop. Where is 118? It is however seen from the records that a vehicle of the petitioner was manufactured in the month of March 2015. It is also seen from a perusal of Rule 118 of the Central Motor Vehicle Rules 1989 that the requirement of having a speed governor would be only in relation to those motor vehicles which have been manufactured on or after 1st of October 2015.
The mode notification date is.
So what is the difference?
The notification, Lordship may also observe the notification about mode notification. It is dated. 15th of
It
April.
is further seen from the notification number notification number ZSR dot 290 bracket E dated 15/4/2015 of the Ministry of Road Transport and Highways that in respect to, this is not required, this is the same, na?
Same, Lordship.
It is further seen from Sub-Rule 2 of Rule 118 of the said rules of 1989 that in respect to those vehicles which have been registered prior to 1st of October 2015, which are not fitted with the speed governor and are not covered under the first proviso to Sub-Rule 1 now those transport vehicles would be required now to be has to be confirmed. Now, is there any notification in terms with Sub-Rule 2?
Vehicles are not registered prior to October.
If well, registered prior to 1st of
October. They have to take it as a liquid after the.
Where is that notification?
I have given the form.
Eighth of July.
15th of April 2015.
No. 15th is the state government will issue a notification.
Yes, that's 8th of July 2022.
What do you say? Guidelines for Brahman related of.
That's 16 clause.
No fitness certificate shall be issued unless the vehicle is fitted with the speed governor of the prescribed time and standard. In case the vehicle is found without a valid demand, where the speed governor pollution is permitted and under section of the vehicle registration can be suspended. Now, therefore, it is the requirement. How do you take care of that situation? First situation is okay, but how do you take care of that situation?
That is the matter. When you are taking the car in the transport sector, then the commissioner has to write the petition to the government has the power.
Huh?
This vehicle is not fitted with SLD. I have been told by the commissioner office, they have to consult with the state of dispute. Because this type of vehicle, some vehicle SLD is not available. This problem happened in his car also.
Yes.
Because the DTO informed me, SLD could not.
No,
fit
don't
his
you
car.
think then this court has to pass an order to the effect
Hello.
that now as the petitioner is trying to convert
The private
to a vehicle where an SLD is not required,
required.
under such circumstances, the
They will take up the-
requirement of the insistence of have the insistence of the fitness certificate. How can there be a fitness certificate be given now?
That's why they have taken up the matter with NIC because Vahan portal is conducted by the NIC. They will take up the matter because now petitioner wants to convert his vehicle to a private vehicle where SLD is not required, my lord. For that, commissioner office will take up with the NIC. The my lord may kindly direct the commissioner office to take up with the all other stakeholders because he now wants to convert his vehicle to a private vehicle. As per law, my lord may.
Because I have to pass an order because if you still insist, means you could have suspended, you have not suspended his registration.
Yes. And lordship may keep this matter as a pending and lordship may kindly
I'll have
observe.
to keep this matter pending because
My
please
lord.
respect
Yes,
has to be dealt with somehow.
my lord. Lordship may
They,
kindly
as regards the speed governor is not required is clear.
my lord.
But as regards the fitness certificate, how can he have now a
Yes.
fitness certificate as of now because it is still a transport?
Transport vehicle. They have to take up the matter. NIC lordship may kindly observe pendency may not be a bar. We'll take up with other stakeholder also and I will get back to my lord after puja vacation.
And lordship, this sub-rule 2 is clear, lordship.
Huh?
118 sub-rule 2, it says that lordship, yes, it is required. lordship.
118 sub-rule 2 gives the power to the state to make a notification. Now the state has made the notification in the month of year 2022, 8th of July 2022. Now 8th of July it makes its requirement. Okay. Now you have a look at this, whether your case will come under or not.
Transport vehicle. Lordship, we kindly have a look at this notification also.
But have you issued this notification in terms with this? This is not a notification in terms with the sub-rule two.
We have a look, another notification I have received. 2007. Because he did not install the SLD while he was using this car as a transport vehicle. This is the issue right now for getting the fitness certificate.
This is of 2017. I think that, and this is by the year, no? This is the government.
Government of, central government. madam.
This is government of India.
India.
That may be exempted under 110.
Para 110 to 180. Speed governor is also included here, my lord.
It matters, sir. They are referring to what law? This notification refers to 110
10.
subsection 10. Power of the central government to make rules, and then subsection 1 TB. 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 Anything contained the state may exempt any motor vehicle or class of motor vehicle from the rules made under the AI. This is okay. But
Why not?
whether there is a notification in terms with that, by the state government in terms with that, the 118.2.
No, I have only given that 2022 notification.
No, that doesn't seem to be a 118.2 notification.
Yes, only because of clause 6 in fit regarding fitness certificate.
Because 118.2 says the state government shall by notification in the official gazette specify on or after remand the categories of transportation registered prior to so and so which are not already fitted with speed governor and are not covered under the first proviso to sub-rule 1 above, that such transports shall be equipped or fitted by the operator of that vehicle on or before remand with a speed governor having maximum speed of so and so by the state government from time to time as amended, provided that the category of transport hazardous and demand dumpers so and so school buses and is not already fitted with the school bus so and so shall be equipped with or fitted with such vehicle with a speed governor having maximum of so and so. So therefore, unless there is a notification in terms with 110, 118.2 by the state government,
Sure.
do you have to specify which are the transport vehicles? Where is that notification?
These are not included in this notification. Lordship, I'll get our instruction. My lord, may kindly observe pendency may be a bar. I will get back to my lord after puja vacation.
लिखोगे क्यों नहीं? Miss, मतलब
And
this court, by an order dated 9/9/2024, had sought for certain instructions from the Transport Department of the Government of Assam. Miss M.D. Bora, the learned counsel, standing counsel of the Transport Department, has placed before this court certain instructions issued by the Deputy Commissioner of Transport. Amongst the instructions, it is seen in the state instruction, it is seen that the Secretary State Transport Authority had issued a letter to the District Transport Officer Kamrup Amingao for permission of conversion of the vehicle of the petitioner from tourist cab oblique tourist maxi cab to private, wherein the State Transport Authority had expressed no objection in the context of the route permit in the conversion process. However, there is an issue relating to the fitness certificate, taking into account that as to whether there was a requirement of having a fitness certificate of a speed governor. There is however, there is an issue as regards the fitness certificate. It is seen that a fitness certificate as on date may not be permissible as stated in the instruction in view of the fact that the petitioner's vehicle did not have a speed governor. This could, however, put a question to Ms. M.D. Bora, the Learned Standing Counsel for the Transport Department, as to whether the state government, taking into put a question to query upon Ms. M.D. Bora, the Learned Standing Counsel for the Transport Department, that taking into account that the petitioner's vehicle was manufactured in the month of March 2015, whether there would be a requirement for fitting a speed governor unless there is a notification in terms with sub-rule 2 of Rule 118 of the Central Motor Vehicle Rules 1989. Ms. M.P. The Learned Standing Counsel submits that some time may be required. She further submits that the matter is also being actively considered by the Transport Department. Accordingly, this matter again on 8th of November 2024. In the meantime, the Learned Standing Counsel shall obtain the necessary instructions. The instruction which have been placed before this court dated 13/9/2024 is kept on record and marked with the letter X. It is further made clear that the pendency of the instant petition shall not be a bar on the part of the Transport Department of the Government of Assam to do the needful for carrying out the conversion.
Keep your blessing.
Hi, dear friends.
That's the whole. Yes. This matter again on 25th 27th of September 2024. Taking into account the instructions so placed before this court, dated 12th of September 2000, instructions so placed before this court, that the department would release the budget within a period of 7 working days.
You may kindly peruse the second bunch also. There is the order by the Kamrup Metro. Sanction is also accorded. Bank details, etc. are also provided.
I have the honor to forward here with the sanction order for Iman. So this was done earlier. No, this has been done, but the release has to be there. No? This is after contempt. The state instructions are collectively kept on record and marked with the letter X. Is there instruction?
So,
Oh, this one,
No, I'm appearing, file yesterday only, take inspection.
file of
All the
objection,
three.
affidavit.
No, I'll take instructions, whether to, what instructions railways have,
What do you want to do? Are you filing your affidavit or not? Or comply?
Take instructions on that, whether
There's no instruction business.
flying or. and the affidavit.
You can't say that you won't comply. Have you filed an appeal?
Appeal has not been filed.
Then you have to comply. Is there a stay?
No.
You are not asking for filing of an affidavit. Then we ask who is the person to be present in the court. Yes, ask these three persons to be present in the court.
File affidavit.
Then, why you not asking? This matter again, Mr. H. Gupta appears on behalf of the respondent number 1, 2, and 3. Full stop. List this matter again on 6th of November 2024. Full stop. In the meantime, the said respondents shall file their affidavit without fail.
May I please, I have filed the Upadan now for the respondent number 3, that is the builder, my lord. I need 2 weeks time to file my affidavit, my lord, response time.
4.
4, 5 are the landowners.
You are?
I am the builder, prime home builders.
And who is the petitioner?
Petitioner is the neighbor.
What happened with?
But if there, we have alleged some violation of rules and regulations of, we have alleged some violation of rules of the building bylaws and on other.
You are the?
I'm the neighbor.
Oh, neighbor.
Neighbor.
Okay, okay. So you are violating him. Okay. What about this person? Respondent number 2 has filed.
2 is filed.
Who has filed? On last occasion,
What is your stand, respondent number 2? Is there a building violation?
There is no building violation. In fact, my lord, Dorsey will first have to the NOC, my lord.
Okay, okay, then we do one thing, there's nothing, we have it
File
for
an
here.
affidavit for the
What
case.
about respondent number 4 and 5?
Here are the landowners, they have not appeared yet. I have got the instruction.
As a service upon the landowners being complete? Huh? The office note does not reflect as regards service upon the respondent number 4 and 5 to be complete. Full stop. The respondent number 3 who appears submits that he would like to file an affidavit.
Affidavit of opposition.
Full stop. List this matter again on 6th of November 2024. The registry shall update on the service upon the respondent number 4 and 5. Full stop. The respondent number 3 shall also file the affidavit.
Okay.
Yes, what is this?
But last occasion, we were directed to hand over a copy to the people, he have taken the steps,
Well, the last occasions, my lord, 21/8/24, my lord.
Hmm,
This honorable court has passed an order, my lord.
hmm.
In paragraph 2, it says, taking into account of the so-and-so, the learned counsel appearing so-and-so is directed to serve extra copy of the writ petitions upon Mr. M. Pukan to the learned public prosecutor Assam, who shall forward it same the respondent number 3 and 4. And here respondent number 3 is, my lord, the officer in charge of my lord cybercrime police stations, Cyberabad, Telangana, Hyderabad. And the 4th is, my lord, Jhansi. Though there is an honorable court order, my lord, I have already taken steps and forwarded the said writ petitions along with the, my lord, honorable court order through email and the as well as the register post, my lord. These are the documents, my lord, which I have sent.
And in response, my lord, they have sent a mail to my office, my lord, in Hindi, it's the Jhansi. The respondent number 4. They sent a response to my mail, my lord, in my office mail in Hindi, my lord. I can't understand what they have.
So what do I do? I also don't understand. What is the other one?
The other one, we have not received any mail from them.
Telangana.
Telangana, yes.
But they have received it.
My lord, yes, they have received.
Both have received.
My lord, yes.
Now, Mr. M. Pukon, the learned the public prosecutor, submits that in pursuance to the order dated 21/8/2024, he have duly forwarded the orders passed by this court in the instant proceedings along with copies of the petition
My lord,
by email.
as well as the court orders also. The email as well as the Malay speed post.
As well as speed force. Pursuant thereto, the respondent number 4 have duly replied and sent him certain instructions which are in Hindi. He submits that he will look into the same and place this court it before this court on the next date.
My lord,
You look into this.
my lord, yes. But my lord, these two respondents are not comes under my jurisdiction.
Understood.
My lord. Even they had not authorized me to appear also, my lord. I have not received any letter from them, my lord. I am appearing. on their behalf.
He has and has placed before this court, and he submits that the respondent number 4 has sent have sent an instruction in Hindi. Full stop. And the same was placed before this court. The same is kept on record and marked with the letter X. Full stop. List this matter again on after vacation on 28th of October 2024. The registry is directed to place before this court a translated copy of the document kept on record and marked with the letter X. And Mr. Sahiwala, you are the state government, the State Bank of India.
My lord.
Indeed. So you are the person who have blocked the account.
My lord, on the instructions of the police, my lord.
Okay. But how long can a person block it? Account? Is it possible for a long time?
Perhaps, my lord, some kind of fraud that has been alleged.
No, that is some person paid some amount to
My lord,
something,
yes.
and on the basis of which the all these things were being purchased and they were paid certain amount.
Correct, sir.
And because of that, the entire bank has been stopped. This is too much. Anyways, we'll take it up on 20th.
Much obliged.
Yep,
My
yep.
lord, with my
Taking into account and list this matter again for admission. Taking into account that the service is complete, list the matter for admission on 28th.
much obliged. Neglect my appearance in necessary.
Not
Much obliged.